ahead and get started.
Alrighty, good morning, everyone. It is 10:01, so I want to respect everyone's time and get started. I know that there's a couple of folks still joining us and popping in the waiting room, and they'll get added into the room as we progress. Wanted to welcome everyone to the Fall 2022 Property Management Forum hosted by Colorado Association of Realtors. We do this twice a year to help our members stay in touch with what's going on in the property management sector. In 2019, we did a membership survey, and at that time, over 18% of our members did some sort of property management, either for clients or consumers or for their own property management needs that they had for their own rentals. So we're getting almost close to 20% of our membership doing that. So we've heard loud and clear that our members want to hear more about what's going on in property management, whether it's the legal side or the legislative side. So we've got an action-packed agenda for you today. As you guys have been entered into the room, your microphones have been muted. We're going to ask you that you keep them that way so that we can hear our presenters present. And as they finish up, and at the end we will have plenty of time for Q&A. You'll be able to submit your questions via the chat, and then we will also take some live questions from some of our members as well. So keep those questions in mind and save them for the end so that we can do that. Today's session is being recorded so that future members can see it, or that you can go back and replay parts, and that the slide decks from some of our presenters will be available as long as the presenters are okay with that. So there is no technically CE for today, but if you have questions, you can reach out to staff and we'd be happy to handle those. Yeah, I think that is it on the house.
Did you get CE credit?
There is no CE credit for today.
Okay.
Cool. With that, I will get us started so that we can get right into our content. Our first speaker today is Pete Muscio with Cheddar Sulzer, Colorado's #1 eviction attorney. Pete is a senior attorney with the firm, practicing in the area of landlord representation since 2003. His practice encompasses a wide range of issues with heavy emphasis on litigation arising out of landlord and tenant disputes. He's argued in front of the Colorado Court of Appeals and regularly in front of the county courts, district courts, and the federal bankruptcy court. Pete has developed and presented continuing education classes for brokers, attorneys, and has given multiple presentations to the Apartment Association. Pete was elected onto the board of directors for the Apartment Association in 2021, and is representative and he is a representative for the Denver chapter of the National Association of Property Managers, and is currently a member of the Advisory Council for the Colorado Landlord Legislative Coalition. With all that, let's give a friendly, warm welcome to Pete with Cheddar Sulzer. Welcome, Pete.
Thanks, Aaron. Appreciate the introduction, and I realize it's kind of a mouthful. I mean, when you start off with just my last name, Muscio, and then you go into Cheddar Sulzer and then all the other stuff. So thanks for working your way through that. Let me get the slideshow started here and make sure this works. All right, is the main slide up there? Does that look all right? All right, thank you. So really today, I want to talk about kind of a hodgepodge of different issues and give a little bit of an update on what the legal climate is for property managers and what people are facing, and kind of talk about several things that are out there in the industry that have a big impact on the operations of dealing with property management, right? And so there's a lot of little changes related to how things are done in a default situation. It's a big part of what we deal with, and a big part of what my firm deals with is dealing with evictions. And so I'm going to certainly talk about how that impact and some of those changes have had some impacts on eviction cases. I think that's important to understand, because for those of you that are involved in property management, I know that it's great when everything goes well, people follow agreements, obligations are honored appropriately. But you have to also be aware of what happens when things go wrong and what to expect, so you can better prepare for dealing with that issue. I'm going to talk through an example from an actual case of that happened, and kind of talk about some of the specific challenges that particular landlord dealt with, And I think it's really important to talk about that case from the context of how some of the changes in the law have impacted things, and then also kind of highlights an opportunity for what other resources might be available and might actually kind of tie into some of the things that some of the other speakers are going to talk about too. So that's why I wanted to talk about that case. I'm going to talk about, again, kind of that time change in the context of new laws, and then also talk about some new proposals that are on the books, and then maybe some rumors of what might be happening moving forward. And then for those of you that have any connection to Denver, we're going to talk about kind of the impacts of the Denver licensing and how that has had an impact on the industry and will continue to have an impact on the industry moving forward. So not going to be a deep dive on that, but just kind of talking about what to expect in dealing with that Denver licensing. So really want to talk about dealing with the timelines for bad behavior, right? So there were a lot of new law changes over the past couple of years, and COVID-related modifications to court procedures that have certainly slowed things down. And one of the areas that I want to focus on is what happens and what did particularly happen to a landlord when a tenant was really dealing with a very poor behavior, right? One of the things that a lot of people have heard about is the change from a 3-day demand to a 10-day demand. And a lot of times that's in the context of dealing with a demand for payment or possession. That is the most common default situation that landlords and tenants run into, is not paying rent. Well, when that law changed from 3 days to 10 days, that was not just a change that affected the rent demands, it also affected the demands for compliance. And a demand for compliance is very similar to a rent demand, except you're saying, hey, look, we're not talking about the complying with the rent portion of it. We're talking about compliance with some other provision of the lease agreement. And so the way that those demands work is you're giving somebody a demand for compliance. You're saying, look, you violated this portion of your lease agreement. You have this period of time to cure that violation. So if you were talking about somebody that was having a party, it used to be you give them a 3-day demand, and during that time period, they could continue on with the party. Now, that would be one heck of a party to go on for 3 days, right? But they would have that time period. They would just have to stop the party when the notice expired. Well, now if you take that same time period and you add another week onto it, you can see the complications that can be presented when you have an ongoing breach of a lease agreement. So the situation that we're talking about here is we have a tenant that was being very verbally abusive to the landlord. They were sending barrages of texts to the landlord at all hours of the night. The landlord in this particular situation happened to be, I would say, a very sympathetic landlord, a landlord who was a widow and was dealing with trying to manage this property. So the texts that the landlord was receiving were rambling, they were incoherent. These were some of the ones that I felt I could publish here, and I did get permission to share some of this information about, very threatening behavior, very erratic behavior. Clearly there was something that was going on here, and there was, some threatening language that was very aggressive towards the landlord that was unprovoked as well. So we have a situation that is, certainly very disruptive, a violation of the lease agreement, and that creates a problem for the landlord, right? So that eviction demand that was given is that 10-day demand for compliance. Basically, stop doing what you're doing. Stop doing this communication. The tenant here was allowed to continue that behavior, right? Because that's what the law allows them to do. They didn't stop right away. Some people will, if they get a notice, if they're told, hey, look, you need to stop doing something, they will correct that. In this situation, that did not happen. And this was behavior that was not just directed towards the landlord. So as you saw in some of those texts, they were talking about having parties and having people over and creating disturbances. This was a situation where there were shared walls, right? So the tenant's behavior actually escalated after they received the notice. So they were doing things like running hot water and draining the hot water heater for the entire building. They were damaging the kitchen cabinets. They were causing destruction in the unit, making aggressive comments towards other people. And this behavior just continued to escalate. And it got to the point where it was reached the level of a substantial violation. As you can see, this is a picture of what happened within the unit during this time period where the tenant was there. And this is bad, right? And it rises to the level of a substantial violation at this point, which can change the type of notice that you can give. When you have a violation that is substantial, it's all about the words, right? Substantial doesn't mean, is it substantial to you? Like, hey, this is a big deal. This is harming me, because the tenant's not paying my rent. So this is substantial. No, there's actually a definition for substantial, and it has to be a threat to a person, to property. It has to reach certain levels of, could somebody be arrested for the behavior? Is there police involvement that is taking place, that is intervening in the situation? So here we've got significant destruction, we've got significant disturbances, and a 3-day notice to quit for substantial was justified and was provided. So the judgment for possession was eventually obtained. The writ of restitution was executed, and the writ of restitution is that instruction from the court to the sheriff to say, restore possession of the property. The landlord in this situation was left with thousands of dollars of physical damage. As you could see, they didn't have a realistic hope of recovery, and there was at least 3 months without rent, and also attorney's fees that were incurred. So this was a really challenging situation. And could that situation have been avoided? It's hard to say, right? But the timelines, in order to deal with kind of the cure and the levels of proof that were needed to get to the substantial violation, really cost the landlord some time. But I think this is also important to know that this tenant was not on any sort of a voucher or anything like that. They didn't have any other supportive guarantor or any other network behind them that would give an additional support to the landlord in dealing with this type of a situation. So I think the context for why I brought that up might be more apparent too when you hear some of the other speakers later on that might talk about some of the additional resources that might be available for landlords in dealing with certain situations. So I do want to talk about how some of the rule changes have had an impact on evictions and the eviction process. Things have slowed down significantly. So there's a modification that there's an advisement in the summons that goes out, and the summons is saying, hey, look, you need to come to court. And the summons packet for all evictions used to only be a page or two, right? And the whole packet itself usually was very thin. Now, the postage on that has gone up significantly because there's additional advisements that are required both from the state level, and then local jurisdictions have additional information, so that if somebody is receiving an eviction lawsuit, they're basically getting a small book of information. And it is certainly debatable whether or not this information is helpful to explaining everything that's going on. Certainly the intent is to say, hey, look, there are law changes. These rules need to be provided to provide more of an explanation. But I think there can be a little bit of a disconnect if people are getting that information and understanding what to do next and dealing with that. There's also a change dealing with the writ of restitution. That's that instruction from the court to the sheriff that says, hey, look, you have to restore possession to the landlord. So after you go to court, if you get a judgment, you can get this writ of restitution to then go to the sheriff. Used to be 48 hours before that writ could issue. It's still 48 hours before the writ can issue, but now there's a 10-day delay period from when the sheriff can execute the writ of restitution. Also, there's a change to when default judgments can enter. It used to be you had to appear in court at a particular time. If you didn't appear at that particular time, then a judgment would enter that day. That's no longer the case. Now, tenants have until the end of the day before they could file a response. So there's a timeline on their summons, but if they don't appear, they don't show up, they can come into court later that afternoon and file a response. What that has done is that has slowed down the court's ability on dealing with processing cases and created an additional delay before judgments get entered, which delay ends up costing more time for the landlord in dealing with getting that writ of restitution. So I'm going to switch over and talk about some existing proposals that are out there right now. One in Denver is a proposal, it's called 365. It's basically a proposal for a $75 a door for every tenant, every property that's rented out, that would go towards funding eviction defense for all tenants. What that means is that basically there would be almost like a tax on every unit, and that $75 would go to not to pay for rent. It would actually go to pay for attorneys to represent tenants, regardless of the tenant's income status. Now, the link on there is a link to a No on 305 Denver that has additional information about that proposal. The thing is that this proposal doesn't help the affordability of houses and of dealing with rentals. What it does is it increases the cost for rentals within the city of Denver, and it doesn't do anything to help that affordability piece. There are already many organizations that are geared towards helping representing tenants dealing with eviction defense if they qualify based on income. This language in this citizen's proposal has no qualifying language, and it could be very significant. I think the estimates, according to the white paper, are it's close to $7 million that would be going to fund just the attorneys alone. So it's something to be aware of if you have a property in Denver, if you have an owner that has properties in Denver's, that they might want to consider voting no on that because of the increased cost that they'd be looking at. I think the other thing that landlords would be looking at if that passed is that they would have increased costs for themselves as far as dealing with an eviction process, because they'd probably be dealing with an attorney on every single case, whether they had an attorney or not as well. So let's talk about what the future might have in store, future proposals. And let me see here if I can get there we go. So this list is a little bit of a rumor mill, right? As far as what might be out there, what might be coming. We don't know, haven't seen these yet, haven't been drafted yet. The legislature doesn't go into session until January, but there's some things that are being talked about that we might see proposed. We might see some form of rent control. Last year, we saw a version of rent control that was proposed in a mobile home bill that actually got vetoed. But we might see this again. It's something that happens with some regularity where there is a proposal related to rent control. However, what have we seen over the past year? We've seen increases in rents. So we're certainly likely to see some type of proposal related to rent control. We're also expecting that we might see proposals related to security deposits. And with that tie into security deposits, that could be a limit on the security deposit itself. It could be requiring some mandatory installments of the security deposit. So if a tenant was paying a security deposit, that the landlord would be required to break it up over a period of time. So we could see some changes there. But wait, there's more. We might see this newer is the acronym for the no eviction without representation at the state level. There's some rumors that that might be proposed. So while we see that in Denver, it is also a proposal that did get passed in Boulder. Now, Boulder is very different from Denver in so many ways, but when you're talking about dealing with evictions, the number of cases that you're talking about in Boulder are significantly fewer than in Denver. So in Boulder, the attorneys that are providing eviction defense are there in court on the return date, and every tenant has the opportunity to have an attorney and to go through that process. The process, certainly it gives them representation, but it also slows things down from a landlord's perspective typically, and it slows down some of the processing. There can be some benefits as far as getting that back and forth and having that dialogue, but that could be something that we might see at a state level, and that could certainly add to increased costs for landlords, operating costs, and certainly when you're dealing with a default. There's also some rumblings that there might be a proposal related to mandatory lease renewals. And now that might be a situation where you would be required as a landlord to offer a renewal of a lease agreement. This is a concept that certainly could bring some challenges to landlords because right now, unless you are a specific type of landlord with federal funding, most landlords have the ability to say, look, we're not going to renew your lease agreement as long as they're doing that with a legitimate business reason in mind. But there are some proposals that might have an impact there. Also, we might be seeing more mobile home legislation. It seems like that is a popular area of that the legislatures like to target, and there might be some more there. In addition to all of that, we might be seeing prohibitions related to rental insurance, maybe seeing requirements to have courts allow virtual appearances or mandate virtual appearances for all evictions. Virtual appearances right now are something that is still fairly common and probably something that some courts have moved away from in some areas. Like some courts are saying, hey, look, you got to come back in now. We've allowed virtual appearances, but we need you to be here. I think one of the big things that's important about that is, the importance of being in a courtroom and the being able to talk with people and having a back and forth and having a dialogue certainly is a lot easier if you're in the courtroom versus trying to deal with something virtually. And then also you see all sorts of different things when people appear virtually. I'm sure you've heard all sorts of stories about mishaps with Zoom and everything like that. It's certainly something that can happen as well. Another thing to be aware of is the ERAP program is currently winding down. So ERAP is the Emergency Rental Assistance Program. There have now been kind of more restrictions as that program is phasing out as far as the funding. The impact of that's going to be certainly felt by both landlords and tenants because numerous cases involving non-payment of rent have been resolved related to the Emergency Rental Assistance Program. And if that cure is not available, that's probably going to change what the resolution might be and what the benefit might be for both sides of the equation on that. And one thing that I think is always important is that when you talk about laws that favor landlords or laws that favor tenants, is that there's really this need for both parties need each other, right? If you don't have tenants, you don't have landlords, right? And there's kind of this mutual need. I think sometimes that can get lost in the discussion, but it is certainly important to keep in mind. Denver home inspections. So this is a switch to Denver licensing. So if you have properties in Denver, I'm just going to kind of go over these fairly quickly, but you have to have a rental license in Denver. There's a couple of phases to this ordinance. Phase one actually kicked off in January of 2022, and that had some requirements with a lease where a landlord has to provide a tenant's rights and resources packet with any new lease that is entered into. In addition, that packet also has to be served when there's a non-payment of rent demand that is given to a tenant. And that's for properties that are within the city and county of Denver. Phase two of this is dealing with apartments. Anybody that is a multifamily property has to have a license. Key thing with that license is you have to have an inspection. The inspection is something that the landlord has to pay for. So there's an approved list that the city of Denver has as far as inspectors. You would have to have one of those inspectors do the inspection, give you a report, and then you apply for your license. The city has a website that's set up. They also have a video that is set up that walks you through what you would have to do in dealing with that. So if there's anybody on the call that has a duplex in Denver, this is going to apply to you. Phase three is going to apply to all single family homes, individual condos, and row houses. And that begins at the beginning of next year. So the inspectors are going to inspect the units. They have a checklist that the city has provided where they're looking for health and safety issues. Again, there's another requirement that is part of this bill, which is something that I believe most landlords do already, but there's now a Denver requirement that you have to provide a copy of the written lease to the tenant for any tenancy that exceeds 30 days. So again, that's also providing that tenants' rights and resources packet, and at any time serving a demand. With the inspections and with the licensing, if your owner doesn't do it, if you don't get that done, there are consequences. So that could be a violation of the city ordinance, and the city can fine landlords for every violation, property owners up to $1,000 per violation, and require payments quite promptly. So take a look at the Denver rental licensing page if you are managing a property. If you own a property that is in Denver, you're going to want to be aware of this. You're going to want to be on top of it. Again, if you have a multifamily property, you have to have that license by the end of this year. If for just any property that you're managing, you're going to have that for a single family home by the end of 2023. So, and then also there's a link to that video. I think it's really important to be able to understand and be prepared for dealing with the content of what they're asking for in that application. Good news is the city did dial back some of the requirements that they had related to that application to make it a little bit easier and more approachable. But it is still about a 40-minute video, and it is worth watching to make sure that you're prepared to do that. So I think that pretty much covers it. I'd be open to questions after we get through all the other speakers, unless there's something else that I can answer right now. But I think that covers the slide portion of the presentation.
There you go. Thank you, Pete. I thought Halloween was over, but apparently scary stuff coming down the pike.
Yeah, you know, I really get to give people good news, right? People listen to me and they're like, "Why am I talking to you?"
Right, we appreciate it. Looks like you've generated some chat in the box, so I'm sure some folks will have questions for you when the Q&A part comes up. Our next speaker, kind of on a different topic today, is Laura Kitts. She's with Housing Connector. Housing Connector is a bridge that connects private property owners and managers with those who need housing most. Laura is the director of property partnerships, and her team works to partner and support those property owners and managers who work with housing applicants. So Laura, tell us a little bit about your program and what you guys do.
Thank you, Aaron. Good morning, everyone. I am so grateful to be able to take a few minutes and share a little bit about Housing Connector with you. I am also incredibly grateful to be able to follow Peter, because he had a really great example of, I guess, things that can go wrong and where there might be opportunities to utilize guarantors and solutions that can help protect landlords when they are renting to residents. So I'm going to share a little bit about what we do. I apologize in advance if you hear dogs barking in the background or running around. I have a house full of animals. All right, so Housing Connector is a nonprofit that started in Seattle. We just celebrated our 3rd anniversary over last weekend, and we expanded into the Denver metro area about a year ago now. What we do essentially is we work as a bridge between property managers and community partners or case managers who are helping those that are most in need of housing. And when I say most in need of housing, I am talking directly about those who are facing homelessness or are currently unhoused. You know, there's a national shortage of 7 million plus affordable and available rental homes across the nation, and over 500,000 people without homes. The demographic that Housing Connector works with specifically is typically those that have a voucher that is there to pay their rent every month. So there's guaranteed rent coming from that voucher. The other really important thing that I want to share right up front is that every one of Housing Connector's applicants already works with a community partner or a case manager. So we believe that no unit should sit vacant while there are individuals in need of homes, and we're on a mission to help change that. We cannot change the housing crisis without property partners, landlords, property managers. So we're here to help increase occupancy rates for our property partners, reduce turnover, and at the same time increase housing to those that are most in need. And now I'll share with you exactly how we do that. So I guess one more thing about the problem first is that you've got all these people who are facing the housing crisis, that are unhoused, that have vouchers, that are there to help pay their rent, but even in spite of their ability to pay their rent, they're still running into barriers with getting through the screening criteria due to their credit score, income to rent ratio, past debt owed to a landlord, prior eviction history, rental history, criminal history, and then for a lot of those also lack thereof, so lack of a credit score and a credit history, etc. I think that Housing Connector has a really interesting and unique solution that we're working towards, and it's working really well so far. Just anecdotally, we've now housed over 3,500 people in the last 3 years, with 86% of those people remaining stably housed 1 year in, and 74% of those people remaining stably housed and graduating from our program after 2 years. So here's the solution that we really need property partners to partner with us in order to do. But we are offering landlords that partner with us and rent to Housing Connector applicants really a kind of a guarantee package or an insurance package that includes free referrals to you from potential renters through a Zillow hosted platform that was built out just for Housing Connector and is accessible just to those case managers or community partners that we are partnered with on the other end of our bridge. So we help fill your vacancies with those referrals. And then once a resident moves in, we offer 3 months of guaranteed rent payments during the first 2 years that that resident is a tenant of yours. Those can be partial months of guaranteed rent payments. They can be full months. With the voucher holders, that doesn't come up as often, as we do have some clients who are paying with rent from, or paying rent with income from a job. And that's probably where you see the guaranteed rent payments come up more often. For example, 1 month they have their car break down and now they have to choose between fixing their car so they can get to work or making that rent payment, and now they don't have to make that decision because we're there to jump in and help. We also offer $5,000 in damage mitigation funds to the landlord. So if your property has damage caused by a renter, either during their tenancy or after, we have that additional $5,000 in damage mitigation funds to help kind of make you whole again. On top of that, we offer a month of vacancy loss payments. So if you have a renter that is from Housing Connector and they move out midway through their lease, not only will we help you fill that vacant unit again with the Zillow lead, sorry for the dogs here, but we will also pay you up to a month of vacancy loss during that time to, again, help keep your business financially whole on that unit. On top of all the financial support, we also offer 2 years of stability support for the renter, the tenant. You know, for people who have come out of being homeless, they often need some additional support in learning how to be the best renter that they can be. So the case managers work with them for a total of 2 years in support with being that good renter. And then on top of that, we are the direct, like, #1 point of contact for the landlord if something comes up with your renter. So if you have a Housing Connector renter that is having a behavioral lease violation, you don't have to work with the case manager. You get to work directly with us. We work with the case manager, really take that pressure off of you so you can focus on other parts of your business. And then we will help resolve those solutions or situations with solutions. So you get support from us, the resident gets support from the case manager, there's financial backup for you on top of that. And when we do that, we partner also with those community partners who then have access to the Zillow listings and pre-negotiated screening criteria that we negotiate with the landlord to help reduce those barriers with things like the credit score. And let's see here, let's just jump forward. I think I already mentioned the 2 years of case management, etc. So with our partnership, there is an ask from the landlords in turn for providing those benefits because we're helping reduce the barriers with those applicants. So we are asking the partners that work with us to reduce their screening criteria when it is an applicant working with a case manager that is one of our partners already, and in turn are giving that kind of insurance package as a backup. But we're looking at trying to reduce credit score, past debt owed to a landlord, income to rent ratio, the rental history, past evictions, and criminal history. So if I talk about those just a little bit deeper, we typically are seeing landlords who are willing to waive credit score and credit history, are willing to accept an applicant if they have past due debt that is less than $3,000 to a prior landlord. We typically ask for 2 times the income to rent ratio, waiving rental history, accepting up to 2 evictions in the past 3 years, and then criminal history specifically on a case-by-case basis. And these are all screening criteria that as a landlord, you have to be really comfortable with. So these are negotiable, but we do try to keep them as close to boilerplate as possible because the whole goal is just to reduce those barriers. And then I mentioned that we have an exclusive search platform that was built by Zillow. So Zillow is one of our biggest partners. And when a case manager logs into Zillow, they're able to select a filter that says accepts Housing Connector. When they click that filter button, then they're able to see just our inventory only, along with that screening criteria that we have negotiated with each landlord. So it can look a little different for each landlord based on what they were comfortable with. But here's an example of what one of those Housing Connector listings would look like. We would capture right here the screening criteria, and that case manager would be able to inquire on behalf of their renter. And it would come in and it would say, I am, so-and-so with this organization inquiring regarding my potential applicant. So they're setting themselves up in that first message to let you know that they're one of our partners working with an approved applicant. Once a lead is received through Zillow to the landlord, then it's the landlord's business as usual in how they put an applicant through their application process. As long as they're using the reduced screening criteria, the rest of it is business as usual for you. You're able to charge, what you want to charge in your rent and your move-in fees, as long as they're within the local laws. And once the resident moves in, that's where all the additional supports start to kick in for you. We already talked a little bit about how they're able to filter and see just our listings. And here's the life cycle of a Housing Connector applicant. So partnership is formed. We help fill your vacancies. The resident moves in. We offer our support and are here for the first 24 months of their tenancy. And I think the other part that's really important to talk about, we already talked a little bit about how we're here as the first point of contact for the landlords, but we have a support inbox and a leasing inbox. So if you have issues or questions through the lease process, we're here to help. And if you need support with lease violations or unpaid rent, damage mitigation funds needed, etc., our support team is here for that too. And one of the things that we are really proud of is providing a really great customer service experience for the landlords that we partner with. We can't do this work without your support and believe that your business truly has to come first. So we are quick to respond. We are quick to make payments when needed. We don't believe that you should have to spend months trying to track down those payments or get your issues resolved. And this is just another kind of glimpse of where we are right now. These numbers are up a little bit, really, but I think we're over 1,300 households and 36, not 3,500 residents housed now. We have over 1,000 properties that we are working with, which equals many thousands of units. We have a lot of multifamily partners. We have many single family home, duplex, small landlord partners as well. And the property partnership kind of success that we've seen has been really incredible so far. So we're always welcome to share referrals and just feedback from other landlords that we have received. And I'll just say, in the Denver area, we have a great need for landlords to partner with us currently. It's been a slower start in Denver than it has been in Washington State. So if you are interested in learning more, I'm happy for this slide deck to be shared out. Thank you for being able to do that. On the back page is my email address. I can also drop it in the chat. And then there is a QR code as well that you can scan that will take you directly to Housing Connector's website on an inquiry page where you can pop in your information and that will come over to us in an email. That's Housing Connector in a nutshell. I would be happy to answer any questions that anyone may have. And thank you so much for your time. And sorry for the crazy dogs in the background.
So thank you so much for your presentation. There are some questions in the chat. I
Yeah.
don't know if you are comfortable going through and addressing those individually. Otherwise, I know that we're going to have a Q&A at the very end of the program.
Yeah, well, unfortunately, I have to drop off like 30 minutes before the call ends. Is it okay if I go through a few of these questions now?
Yeah, we are actually doing great on time, so go for it.
Awesome, thank you. Yes, our presentation is a little bit short. So let's see here.
And I do have some of these captured.
Oh, thank you.
It looks like there was a question on whether you are state funded, federal, or private.
That's a great question.
It was really a comment that they do not have this on the Western Slope.
Okay, yeah, we are funded in a couple different ways. We do have lots of state, city, county funding. We also have private funding that we receive from donors as well. And that's a little bit different in Colorado than it is in Washington State. I believe we're more privately funded in Colorado.
Okay, and then another question, if we buy a 200 to 400 unit project, do you work with properties of that size?
Absolutely. When you have multifamily, it opens up so much more availability. So we work with a lot of multifamily. The bigger, the better, but we love working with anyone, small or large. Every single unit that becomes accessible is so important to us. So that was a really great question. Thank you. I want to just call out, I see the question about fair housing. So we are huge supporters of fair housing and believe that it needs to be followed at every step of the way. I know that the idea of reducing screening criteria for some feels like it could be a fair housing violation. However, when you are working with case managers that have vouchers along those lines, and you're willing to then reduce screening criteria for them, it actually is not a fair housing violation. And if you want to talk about that more, feel free to reach out to me directly. I've got some great information that I can share with you about it.
Perfect. And I think that that was pretty well the extent of those questions. And you all feel free to reach out to Laura directly if you have additional thoughts or questions. Thanks, Laura.
Thank you everyone so much, of course.
All right. So we're doing great on time, everybody. I'm hoping we can get everybody out of here a little earlier, at the very least, give you plenty of time for Q&A. The next part of our programming will be our legislative preview. We've got 3 folks joining you for a panel for that. I would like to introduce them. First is William Much. William is joining us on behalf of the Colorado Landlord Legislative Coalition. William is president of Much Government Relations, handling government relations at the local, state, and federal levels. William has a strong track record of managing associations, winning candidate campaign and legislative issues, building effective grassroots programs, managing political action committees, fundraising strategies, and building and managing broad legislative coalitions. Next, we have Elizabeth Peets. Liz is our VP of Government Affairs here at CAR. Liz directs the public policy efforts of the Colorado Association of Realtors and manages many functions of the Government Affairs Division, but she specializes in policy development, advocacy, and legislative affairs. She also oversees CAR's Legislative Policy Committee and candidate endorsement process through the Colorado Association of Realtors Political Action Committee. We'll also be hearing from Jesse Zamora. Jesse joined CAR in March of 2022. Some of his areas of responsibility at CAR include coordination of government affairs committees, monitoring legislation and policy issues, supporting RPAC fundraising, interviewing political candidates, generating government affairs communications to general membership, and ensuring successful political advocacy for CAR. I believe we are going to get started with Liz. Is that correct, Liz?
Doesn't matter. I don't think we're in a super order here. We'll probably all piggyback off each other, but I can kick us off.
Perfect.
Wonderful. Well, thank you everybody for hanging with us. I know this is a lot of content and this is why you all tune in. I'm going to touch briefly on some of the issues we know are coming, with the caveat of it's actually still pretty early in the legislative session for us to see actual drafts. So a lot of this is you're getting the cutting edge rumor mill of what we think is coming. And I think Pete did a great job of kind of previewing some of the issues that William and I are probably going to talk about. I won't spend too much time on this because I think Will's going to spend a little bit more time on this, but we are definitely going to see rent control in this session. And the reason I will tell you, you're going to see some of this policy, just the why behind why it's coming back again. The House that is coming in, some of the safe seats that we don't have to wait for election day to find out, is going to be a lot more progressive with some of the incoming new freshman Democrats. And some of them, unfortunately for us, are not super friends of property rights. They're more tenant friendly, I would say. So we anticipate that coming. And I do think it's going to be a lot more pressure on the governor who vetoed rent control in the past because of, as Pete alluded to, the high cost of rent. So the argument is going to be emotional, as it always is, against rent control for us. But we also have some really interesting things that we're going to be able to point to in the session. Florida had a major win a couple of days ago. A case came down from their Supreme Court that basically overruled rent control on the ballot before anyone's voted on it. It's going to have some really great legal precedent for us to use. And there was a great study out of Oregon about how it doesn't really work. So it's definitely an issue we're going to be working on. I haven't seen drafts, but I would anticipate, if I was a betting person, that we will see some version of every local government should get to decide. So basically overruling the Tabor prohibition. That's what they're seeing in Massachusetts right now. And so I think a lot of those unfortunately good and bad ideas travel fast in our quick social media environment. So we are going to see that. I see the question in the chat about rent control and short-term rentals. I don't believe the issues are as directly connected as you're anticipating. I do think we're going to see short-term rental policy, but it is an open target of what we might see. Last session, some of the stuff that didn't get done on short-term rentals that people seem to agree on was asking the platforms to provide more information. CAR, as an organization, we're kind of agnostic on that piece of it because we're obviously not the platform. And I think there's going to be a lot of conversation around institutional investors and whether or not they are making it harder for first-time home buyers. Again, we don't yet know what policy might be coming forward to address that, but it's definitely going to be a topic of conversation, and we're doing a lot of research on, is there a nuanced way to think about it without hindering the housing market? You're still seeing a lot of mountain communities push for short-term rentals affecting affordable housing. Again, I would tell you that's not a direct causation, despite what some of our high country folks will say. Speaking of affordable housing, one of the other things that we're definitely going to most likely see, and I say most likely because we have to wait and find out what happens on Tuesday, November 8th. If Proposition 123 passes, there will definitely have to be enacting legislation to put forward some of the details of what you can't put on a ballot measure, right? We have single subject here, so you can only put so much in the title and so much through the title board, but the devil will really be in the details of this program. And there's already a lot of conversations around the ARPA dollars had higher AMI limits that we passed last year, and those are going away in 24 and 26. So there will either be two kind of ways the legislature will be thinking about this. Let's make the program more effective, expand the AMIs for some of those higher rural resorts is what we termed last year, or maybe making the previous ARPA dollars more applicable to the high country and using the ongoing funding for a lower income AMI. I think this is a great opportunity for us to put forward transformational policy and make it so that we can have long-standing affordable housing funding. But what it also means is now housing is part of the budget process, and it has never been that way before. Usually there's standalone bills, they get argued. So that is also going to really impact how housing policy is funded, as it has to compete with education dollars and prison population funding and health and human services, which are the biggest parts of our budget right now. So it will be a really interesting discussion to watch go forward around housing. And then I think the other thing that is the third possible outcome of what we might see is we might see the Capitol focus on harmonizing all the housing policies so that it's not like you have one grant program that does this, another grant program that has different rules and requirements. The stacked regulation is really hard for people applying for grants, but also our municipalities and counties. And then touching on that, one more thing I think that we will be really seeing is some legislation around seller disclosures, whether it's for metro districts or radon. There's a lot of folks who want us to put stuff in the contract to buy and sell, which we do not like. We don't think it's effective for consumers. So myself and Scott and Damien are working on trying to find a way for consumers to have transparent information about their tax burden, but not have it burden the housing transaction. And I honestly will say there's going to be legislation on property taxes because that valuation increase, it is going to go up, and we don't have a fix for it. Last year we had a compromise, but that's going to hit the threshold pretty soon. So we don't know yet what it looks like. Lots of people are going to care about that. And then finally, I want to touch on one last thing, and then I want to kick it over to William because he has lots of really great property management stuff for y'all. We have been really heavy into the conversations around wildfire resiliency building codes. That bill is coming. And what we're trying to do is find the way forward that doesn't affect property transfers. But what you need to be thinking about as a property manager or someone who owns rental properties is there will be compliance, and it's going to either be in some form of defensible space investigations or inspections, I should say, or it will be when the property is sold and a purchaser makes that new purchase, they'll have to potentially invest or at least be able to get state funding to help make their property more fire resilient. I don't think we can say no, that should never happen, but I think what we're trying to do is find the way forward that really doesn't burden property transactions and isn't a huge affordability problem. And that's a moving target, but we're heavy into the discussion and we know it's going to be a big deal, especially on the backs of the green energy codes from last year, which I think is a great time for me to now segue over to William and what he is going to tell you about other pieces of legislation we know are coming. So kick it over to you, Will.
Liz, great being on this panel with you. I just really want to thank you, Liz, and the Colorado Association of Realtors for putting this together. And for, it's a real honor to represent the Landlord Coalition as a lobbyist at the Capitol, and I know there's a lot of crossover with Realtor members, NARPM and CLLC. So thanks for your involvement. Could not do my work at the Capitol without you and all of you being engaged. And I hope that I'm able to give you some highlights that are worth your while. I see there's a lot of people logged on today, and thanks for taking the time. And again, you know, my wife and I are actually landlords. We own a investment property in Boulder, so we also live this life with you and understand. And as I see these bills come across, I also think about how they affect us and our family business as well. So it's good to be really part of the organization in a lot of different ways here. But you've already heard, and I hope not to sound too much like the prophet of doom, but you know, it's amazing. When I started at the legislature in the late 90s, there are very few housing bills in general, and a lot of things focused on growth management because the state was growing so much, kind of how we dealt with all of that, managed things like, you know, growth boundaries and development rights and things like that. And now we're more into housing affordability and housing justice as really recurring issues. And as you already heard, on Pete's list and Liz's list, there's just a pile of bills already. And this is that early process. It's a little later than normal because of the election year. We might have already had some stakeholder meetings, some bill drafts. Really haven't heard of anything on paper yet. It's what we're all hearing from legislators and candidates to kind of expect, and being out in our networks. And again, that rent control that you've heard is definitely top of the pile. And Colorado's had that prohibition on rent control since the 80s, which has stood all this time. It's been eroded a bit. I believe that was 2 sessions ago by the inclusionary zoning legislation, but still the overall prohibition is held. And as you've heard, I would say, you know, we're expecting at least a bill, if not multiple bills on different takes of this, because just looking out there in the media world and what's coming out of the activist community, so many groups have this at the top of their list as the answer to the affordable housing issue. Kind of handicapping this and agreeing with Liz that I see it as a tougher issue with the governor, who was helpful last time, and I'm assuming he's going to be returning. But I've got some hope in being able to fight this off from one about the Prop 123. If that passes, which I think is likely, that should be a helpful defense with some of this, as you have this major new policy coming in. You've got the implementing legislation. So there at least will be an argument about waiting and allowing some of this to work before going to something so draconian, and using some of these examples from other places like Minnesota, who actually had to roll that back because basically they didn't have any housing when they implemented it. So we'll have that on our side as well. Again, our governor, again, assuming Mr. Polis comes back, I think he has presidential aspirations, and I'm hoping that he'll be looking to fill more of that center-right lane in his party. And if that's true, and he's got more of a free hand, not facing a gubernatorial reelection, we can plead with him to be on our side again on this one. So that's a hope there. And then it's a nice segue from the earlier presentation about credit scores, employment history, and all of that. I just think of areas where housing discrimination policy could be expanded with more limitations around just those screening items that were outlined: credit scores, employment history, criminal history, eviction. Certainly is an area on a lot of lists, and that we could definitely see. I think that is going to be, things like that are definitely more difficult issues and more nuanced at the Capitol. So we'll see kind of what kind of a form that takes. I had a meeting with a legislator last week where he mentioned that right to rest is coming back, or at least that's on something he's hearing in his caucus to expect. So, and I went back and took a look. That was introduced a few sessions ago and did not advance much further than its first committee. It's got a lot of pushback even in Denver, but I can definitely see that, especially with a lot of these homeless issues front and center. That coming back as something to watch for coming up as well. And then you might have noticed last session there was legislation around putting EV chargers, electric vehicle chargers, in especially multifamily buildings and larger commercial buildings. I'm hearing that is going to come back, but there's been some brokering already with the governor, between the governor's office and the proponents, where they feel like they have agreement around bringing back some form of this, especially the requirement that the multifamily developments of the new buildings would also require the EVs. And there's also been a lot of articles in the press about housing discrimination on renters who want to have electric vehicles, but are not able to keep them charged at their homes like a regular homeowner would be able to access. So I'm not hearing yet about this coming into the single family, but again, being in that property network in Boulder, we're already seeing the signs of, in a community where you also already have to have a license as a landlord. That definitely gives the municipality a lot of leverage to start having other energy requirements. So we're already getting the early warning about moving to all electric as far as appliances. Not exactly sure where that is on the timeline, but there's definitely, let's say, proponents around those ideas, and to also roll them out more statewide. So another thing to definitely be watching for as well on the energy front. And as Pete had on his list, damage deposits, when you're thinking housing discrimination as an issue, you're definitely going to go to the damage deposit area and look at what kind of limitations you can have on those deposits, whether or not they're, some percentage of income or a cap, or the different timelines that they would be paid, any kind of a barrier to affordability like that. Definitely I see security deposits being on that list as well. So I think I'll wrap up there and just thank again for being, it's one thing to be invited once to one of these panels, but to be invited back for a second time is a nice compliment. So again, thank you for letting me join you for a few minutes this morning.
Thank you, William. That was awesome. Now on to Jesse.
Hi, everyone. So I have an update on Senate Bill 59. This is the HOA voting proxy limitations bill that we monitored this past session. What this bill did is it created a maximum time limit for a proxy up to 11 months, unless it's stipulated that it can be terminated earlier. This was signed in the middle of the session, so March 21st, and became effective on August 9th. Some of the other parameters that were stipulated by the bill include that unit owners provide notice of revocation of a proxy to the presiding officer of the meeting. So you do need to provide that notification beforehand in order for it to be valid. And or it could also be the person who is just having that vested authority in that meeting. So it doesn't have to be the board president. Proxies should also be dated and indicate that the revocation can occur, but that the notice be provided beforehand. And not having those requirements will mean that your proxy is invalid. So please date and make sure you have that revocation notice included. Additionally, I also monitored the Department of Regulatory Affairs webinar. This is sort of DORA's just public-facing webinar to give information on these changes. This was on October 21st, and what it really did is it just gave like a high-level overview of what the HOA Information and Resource Center does and what they're conveying on the changes. They covered the attendance percentages required to constitute a quorum in HOA meetings, and one of the patterns in that webinar is that governing documents prevail, so always pay attention to those. Of course, also looking at state statute, but refer more specifically to governing documents as those will proceed. And then the proxies that are made need to be carefully executed so that the proxy assignment is not deferred to a board president, because in many cases, that's not made correctly, then where the vested authority lies, they can make that assignment. So you just want to make sure you're accurate and precise with that proxy designation. Other things they covered, any proxy can, anyone who's of legal age can be a proxy, and they can be, if there are templates that are provided by an HOA, then it's recommended that you use that. That isn't CAR's recommendation, and we're not providing any formal recommendation here. We're just saying that DORA is recommending that. So please use those templates that an HOA provides, and get those unit members to use those documents just as a form of consistency. And other things that were included in this were that, you know, HOAs, they should abide by what current statute is, including the secret ballots. And that process was very well recommended during that webinar. They just want to emphasize that, you know, if there are meetings that require a vote of 20%, that those secret ballots always be used. And there were also questions regarding the virtual application of those secret ballots. So for instance, here's an example. Zoom might have like a polling function, but, you know, if you can't track or verify who's voting behind that screen, then you might run into some issues. So just want to keep you apprised of that. And that's about it for my update. But yeah, this has gone into effect since August, and those changes are very slight.
Thanks, Jesse, for following all that. Those meetings can be intense. Do we have any other like last thoughts from our panelists, things we didn't cover before we start hitting Q&A?
One thing I would just flag, we are hearing rumors, I don't have details about this, that conversations around statewide residential zoning are going to come up again. Obviously, that opens a lot of can of worms. So more information on that when we know more, but we're hearing rumor mills. And then lastly, I would just take a minute to say, we lost a really wonderful housing champion over the weekend. Representative Hugh McKean passed away suddenly from a heart attack, and he's being laid in state this week. If you know anything about him, he's one of the people in the Capitol who not only is a huge property rights and affordability champion, he's also one of the best humans I know in terms of keeping the building sane and being willing to find the middle ground. So if you do have a chance to tell his family or folks that work with him, thank you. He's really going to be missed very, very much for the next 2 years. So just wanted to take a minute to say that.
Thank you, Liz. May his memory be a blessing. I know we've got an election coming up. Did you guys want to cover 123 and where members can get the ballot guide if they haven't voted yet?
Yes, I am happy to do that. So we are hosting our CAR ballot guide on the CAR website. It's under the advocacy tab, and I'm sure one of our lovely folks will pop it into the chat as well while we're talking. But Proposition 123 is a measure that was developed by the Gary Community Foundation, Gary Community Ventures. CAR is highly supportive of it because we think there are some really interesting aspects of it that have potential to be transformational. It is a continuum of housing approach. So there is funding that supports unhoused, funding that supports rental assistance, and some of the eviction defense program. But the part that we are most excited about, as you can imagine, is the home ownership piece of it. It will allow us to have gap financing and land banking statewide. So gap financing is kind of like LIHTC and us being able to build affordable housing and purchase land early. It also will have down payment assistance, and a huge portion of it is dedicated to what they call workforce housing, the tenant equity vehicle. Is a mouthful, which essentially means rent to own, which is really interesting. So it's Chaffa and OEdit will transfer money to Chaffa and the Division of Housing, and they have the ability to sort of put forward multifamily rentals and then price it so that tenants, as they pay rent, can also earn equity to be able to graduate out of renting and be able to access homeownership in the future. This is not your average rent to own program. It's different. It's a government entity offering it. So it has the ability to be transformational. The other thing that I would say is that one of the biggest things about Proposition 123 is it might be the future vehicle for how we fund affordable housing programs in the future after our ARPA dollars go away. It's $300 million in annual funding, which we know we'll have for the first 2 years because of where we stand fiscally. After that, it becomes part of the budget battle at the Capitol. And no matter where you sit on Tabor, I think one of the things that I am telling folks, whether you agree or don't agree with the method, it's about time that we start investing in affordable housing as one of the biggest pieces of our budget. If we don't do it now, there's going to be a lot more folks leaving Colorado. But make your own decision, and I just highly encourage you to vote, no matter what. Make sure you turn in your ballot.
Voting is key. Can't complain if you don't show up. So thank you for that. It looks like we've gotten a whole bunch of questions that have come in. Looks like the first couple were for Pete. So Pete's back with us. When you talked about involvement requiring a substantial violation, what does that include? Neighbors calling the cops over a loud argument / dispute between the tenants?
Excellent question. This issue does pop up quite a bit, where it's hard to make that judgment call as far as, is this a substantial violation or is this just a compliance violation, right? Where it's something that could be curable. And the common legal answer is going to be, it depends. I'd tell you that for the most part, that scenario that the person that had the question described is probably going to be a demand for compliance situation. However, it just kind of depends on what's going on at the property. What's the underlying basis? Is there a crime being committed? I think if you look, is there an arrest that takes place? One thing to keep in mind too is that you can have, unfortunately, there are a fair amount of domestic violence situations that can occur, and a domestic violence situation actually triggers a lot of protections for the victim of domestic violence. So they would be able to terminate their obligations under the lease if they were a victim. And that can't be the basis for the victim to be evicted. So there's a lot of complications that can come into those scenarios that have to be weighed out, and a good thing to discuss with your counsel.
Okay, awesome. The next one was like a comment question. It says, as the market changes, a lot of first-time homeowners or first-time landlords won't know about all the rules and changes, so they won't be following them. How do you recommend folks stay in compliance?
Well, I think, you look at the people that do this professionally, and that's just a great tool for them to say, hey, look, you know what, here's how I can help, right? Deal with somebody who's licensed, who goes to forums like this, who goes to trainings, who works with an attorney to be able to understand that. It's a difficult time to be a property manager right now. You've got a lot of new things that are coming at you. There's a big focus on the industry as a whole. And, the other challenges as far as dealing with employment issues, we're seeing people have challenges as far as hiring people, getting work done, getting work completed, because there's all sorts of requirements that are out there that dictate different timelines for landlords to solve problems if there's a problem at a property. And it's a lot. So I think the key thing is to, if you've got a rental property and you're going to manage it by yourself, I think you got a long list of things that you need to get up to speed on, and you can either invest the time to do that right, or you can hire somebody that has already invested the time, and they're going to earn their percentage, and you're going to get some peace of mind by having a professional help you with that.
Nice, awesome. Is your firm still taking on new clients?
We are, yes. So
Awesome.
we work with landlords that have as many as one property, and we work with landlords that have multiple units, hundreds, thousands of units across the state.
Okay. I also have a question that came in. It said, does anyone on the panel know about licensing most likely coming to Fort Collins as well?
That's one that I haven't heard anything on. I don't know if anybody else has, but I haven't heard any rumblings on that.
All right. See what else we've got. Pete, the tenant's rights and resource documents is required to be given with all demand notices. What areas of Colorado require it to be served with the document or with the demand?
Yep. So I did post the link to that packet in the chat as well, but that only applies to the city and county of Denver. So Denver is pretty unique. You could have a Denver property that's actually located in Adams County. That property, you wouldn't be required to serve that packet. It's also only required to be served with demands for payment or possession. So it's also required with a new lease too. So, lease packets are, well, I haven't seen a really small lease packet in a while, right? Those things can tend to be pretty large because you got lawyers involved putting them together, and you're trying to cover every single scenario that might pop up, right? So in addition to everything that's in the lease agreement, you're going to have that packet as well. So you have to give it twice. Hopefully only once, because you don't ideally want to be having to serve a demand, but if you have to serve a demand, that has to go with it.
Awesome, thank you. Let's see what else we've got for Pete. Assuming we would just need to have cause, example, owner selling, excessive late payment. Oh, I think it was talking about on the automatically having to give folks renewals. They wanted to know if there was, assuming that you wouldn't have to give a renewal if there was other stuff going on like excessive late payments or violations in policies and procedures.
So right now, like the panelists talked about, as far as forecasting what's coming, it's really hard to say exactly what that might look like in the context of dealing with subsidized properties that have a tax credit with them. Usually low-income tax credit properties. Those properties, you really have to have good cause to give a non-renewal, and it's unclear what the proponents of this legislation might come up with. But if they modeled something like that, those situations, you have to have a good basis. And typically something where somebody's been engaged in multiple violations of the lease, maybe threatening behavior, aggressive behavior that has continued on for a long period of time, might be a good basis for that. But it's just a higher bar that you can't just terminate somebody. Now, in the context of that tax program, it's a very good benefit for somebody to be in that program as far as affordable housing. And the idea there is to help keep somebody housed and to keep them through there, but they don't continue to get that benefit if they've had this kind of continual violation. That's a good basis for the non-renewal. So it's appropriate for that type of a program. It's probably not appropriate for a standard and a conventional leasing situation, because you're really, when you're renting a property, you're giving up a certain degree of rights, right? You're giving up the right to possession. So you're giving that to the tenant in exchange for the compensation that you're receiving. If there was this language related to a requirement that you couldn't non-renew somebody, you're really giving up an additional right when you're giving that lease agreement. And so I think what that does is it could really put another chilling effect on housing. And it's interesting because some of the proponents that talk about these ideas and these concepts, they want to say that, hey, this is good, this is going to protect a tenant, and that this is going to help affordability, when if you look at the big picture, I think there's some larger concerns of what the consequences of these things might be. And I think educating the people who are going to be voting on this about those concerns is really important, and it's really something that I think, as those of us involved in the industry who practice in this area, it's important to be able to advocate for that. I'll give a plug to the group that William does some work for, and I know I saw Lyle on here too, the Colorado Landlord Legislative Coalition. They're really targeted towards advocating and trying to protect the interests of property owners, and really hearing the voices of those that are impacted by these types of laws.
Thank you, Pete. On the car side, I know that we have over 37 members who read bills during the session that make up your legislative policy team. And we not only read those bills, but we go down with Liz and our lobbyist team, and we provide testimony on these kinds of things too. So if you guys have strong feelings, I'd encourage you to apply for the LPC committee or talk to your LPC members and get involved in sharing your thoughts so that we can make sure that things like this don't happen, while we're away at the wheel, so to speak. So one more question regarding the Denver licensing. Somebody wanted to know how it applied to rentals that might be used for corporate housing. So I'm assuming more of a short-term rental.
So the ordinance is really geared towards property owners, and the property owners requiring them to have a license. So it's the property owner that is renting those types of units out that would still be required to have a license and have to go through the inspection process.
Okay, so long-term and short-term rentals. Okay, and then looks like we've got some legislative questions. What is rent control, and what would a mandatory renewal look like? Would rent be fixed, or would it allow for increases up to a certain percentage? I know we don't have bill drafts out just yet, but what are you guys hearing out on the streets?
Yeah, I can grab that one if you'd like, Liz.
Yeah, sure. Go ahead. Well,
So I think it could take two forms. It could be like we saw in the mobile home legislation last session, where you have some kind of a formula that the Department of Local Affairs and their housing division would administer, and some kind of a tie to like a local rate or some kind of market rate with a percentage accelerator. I think the more likely, though, would be just a simple repeal of the rent prohibition, which would then allow local governments to set their own ordinances. I could really see the argument from the municipal league, and you get mayors and city council members just saying, hey, just let us regulate our own housing market and come up with some kind of affordable housing program, is what I'm sure they'd call it, to do locally. And that's been long on their wish list. So that's sort of what I would think would be the preferred form for the proponents to take.
yeah, I think Will's exactly right. That latter part is the path of least resistance through the Capitol, but it's probably also the most damaging, because you're going to have a patchwork of approaches all across the state, and it'll be not a good policy. So I know we will be talking to the governor's office, as I'm sure William will, and others, about why that's a bad idea.
Okay, it looks like we've got some EV questions as far as the charging stations. Some folks would say the tenant should pay for them if they want them. I know it's come up in LPC quite a bit as to how do you make these mandates and try to make housing more affordable at the same time. What are you guys doing on the building and EV requirements?
Well, I guess I'd say it's a little bit of a moving target. So last year, right, the governor vetoed that bill. It was written up in the Wall Street Journal. I think Drew Hamrick spoke to you all about that. And the Wall Street Journal pointed out that was one of the best things he did. But I think you're going to see more energy legislation this session, as Will had mentioned. I think the tricky part about that is the devil is always in the details, because it depends on what your building looks like, because building 3 or 4 stories under where your parking garage is often not feasible to actually have a viable charging station for some of those properties. If it's a brand new construction, you have a lot less path to resistance to put it in. It still is expensive, but the other problem that I think is one of the hardest things for the Capitol to grasp and the policymakers is they don't have a sense of the reliability of the grid. And if we put all this energy forward, climate change mitigating policy, do we have the right technological feasibility to make it work for the long term? Because we all know the prices are going up at the gas tank at the end of the election cycle, the gas taxes are going up. The Biden infrastructure package is going to put pressure on states to incentivize property owners to do this. But the reliability argument of whether or not you have reliable energy seems to fall on deaf ears of the Capitol, no matter how many people say it. So I don't know what you would add, Will, to that, but I think it's going to be a major headwind heading into the next 2 to 3 sessions.
No, I couldn't agree more, Liz. I mean, the expense, I think, of our, and again, as we mentioned, multifamily new construction will be the first thing really on the list for a mandate. But as it goes to the single family side, I even think of our own unit, where we have a gas furnace, water heater, I think it has a gas dryer. And if we needed to upgrade, basically re-electrify the whole home and add an EV charger into the garage, and not just one of the trickle chargers, but one of the, the real fast charge, I think that would be, 15, 20,000 at least. I'm sure, actually, I'm assuming it'd be more than that. We'd have to pass that all on to the tenant. And so we would really even have more of a niche kind of a tenant with kind of this, boutique electrified kind of unit. And obviously we would have to charge for all of that. So those tend to be the best arguments we can make. But again, a lot of legislators really are not interested in that discussion. So it's a tough one. The bigger thing I know on the multifamily buildings, the engineers were a good ally on that, where they just said, my goodness, we're the ones that are supposed to design all of this and put it in place. And the way that this bill is written, it's almost impossible. So that is a helpful ally with the people that are actually supposed to build it. And like Liz said, when you also combine that with, the grid's not quite ready for a fully electrified economy yet, where's all that capacity going to come from? At least that's a different argument outside affordable housing, which again becomes tougher and tougher to make. Sometimes there's just not an understanding of the market forces, and sort of this assumption that the owner is just going to, not pass it on, but just reduce their, investment amount or their profit margin, which is not going to happen.
Yeah, it seems like we come down to the battling the unintended consequences a lot of times in these bills. I know that a lot of the struggles we've had is on electric panels, they put all this stuff in, but then you have to update the main electric to the house, and it snowballs into huge additional costs. If I could get Lisa to help me with a couple of the other questions that have come in, I can't see them all.
Of course, we
That'd
did
be
have
great.
several more that came through. First one I think is more of a Pete question. Source of income is becoming an area that one cannot account against an applicant, i.e. Section 8, but can other rental qualifications such as reserves, credit, etc., can these other sources be used not to qualify a tenant?
I'll say this, there's a lot of protections with source of income, right? And I think the main thing that people really get is, look, you have to accept Section 8, right? You can't, there's no longer a situation where you could say, hey, look, I'm just going to refuse Section 8. Could there be other basis for denying somebody who has a voucher from becoming a tenant? It's certainly possible, especially if the Section 8 voucher is not covering their entire portion, but you have to be very careful as far as how you're applying that. For example, I think, say the tenant's portion of the voucher is $100 and the rent is $1,000. Some landlords will have a requirement that somebody has to make 3 times the amount of the rent. Well, if they're only paying $100, really that 3 times, the qualification wouldn't be $3,000. They just have to be making $300, 3 times their portion of the rent. It is something to kind of keep in mind. So it's a tricky area. There's a lot of discussion that can kind of go into dealing with source of income issues and making sure that you're doing the right thing. So it's a big topic, but I think that the important thing to keep in mind is that, look, you have to accept Section 8, and you've got to be careful as far as if you're doing a denial, what's the basis for that denial, and make sure that you're not discriminating.
So a follow-up question came through on the chat for the Section 8 inspection for taking Section 8 payments. If you have not had an inspection, what about if you have not gone through the inspection on your property? Doesn't that period take time?
It does. And that can be a challenge that people have dealt with as far as saying, hey, look, I've got to get an inspection. So if somebody hasn't dealt with Section 8, somebody has a voucher and they're saying, hey, look, I'm going to give you this voucher to cover your rent, but the provider that is administering the voucher will do an inspection of the property to make sure that it is habitable, right? And so for most landlords, that should not be an issue, because the warranty of habitability, and also you want to provide a good home and a good living situation. But before everything can be green lit, that inspection has to take place, and so that can create a delay. I've heard of longer delays during COVID. I haven't heard of as many delays recently, though. So hopefully that process is getting better and improving.
And some clarification on this subject. Someone is asking, accepting Section 8, is that only for the city and county of Denver?
No, that's statewide. There's a statewide protection on the source of income, and that goes beyond just Section 8, right? I mean, it could be, somebody could be getting an inheritance type of thing. I mean, there's all sorts of different things that could fall under it, but Section 8 is probably the biggest and most common impact.
So if you had two tenants apply at the same time and one had a voucher and required the inspection and one didn't and wanted occupancy right away, could you still choose, the one that wanted occupancy right away over the time delay? Or?
Well, I think that's really tricky, right? Because part of the issue there is, okay, you've got that perfect scenario where they came in at the same time, right? Are you a first in, first out, type of scenario? And are you running some sort of risk that you're only deciding on this one tenant based on the fact that they're not Section 8? I think that it's by itself raises a little bit of a risk, right? Because the whole protection there is that source of income, that shouldn't be the determining factor on making that determination. So you've got to be very careful.
And it looks like the Section 8 questions keep rolling in. It is not required to accept voucher if the owner has 5 of less single families. Is that correct?
I don't think that is correct off the top of my head. Typically, a lot of times we're dealing with the Section 8 situations in the context of property management. So if you're third-party property manager, you're going to have to take Section 8. If your owner just owns one property, you're going to have to take Section 8 with that property.
Okay, it looks like that might be the end of the Section 8 questions. I do have an additional question that I think several panelists may be able to answer. For brokerages that manage rental properties, is a license required?
That would be a yes. So if you're third-party fee managing, you're required to have a license in the state of Colorado. And then we're going to be talking about the other licensing that we talked about earlier as far as Denver. That licensing requirement is required at the ownership level, but I think it's also, if you're third-party managing, you better make sure that owner has the license, or that you're assisting with that process, because if not, I think there's an argument that could be made that you would be engaged in a licensing violation of your state license. So
So Aaron, I think that's the end of chat questions. I think we can invite people to raise their hand if they've got any questions they would like to ask live. The reason that we like to do that is just so that people aren't trying to talk over one another.
Yeah, and in the meantime, I did have a question if William was taking votes on his color swatches, so.
I was wondering if someone would bring that up. You know, obviously, we're doing a little renovation work on the home office here, so. Yeah, so
Very
if you
cool.
have an opinion, you know, go ahead and send it out.
Before we started live today, we just made a comment that, you know, William was trying to match Pete's colors, so. Do we have any hands raised? I'm kind of scrolling through.
I do not see any hands raised. Does anybody have any questions for any of these fine speakers?
So I have a question for the CAR folks. What's the best way for members to participate in dealing with the legislative issues that you were talking about too, and kind of engaging on that front?
I think Aaron kind of alluded to this. Apply to be on the Legislative Policy Committee. Actually, next session, we have 44 members of LPC, so it's a much bigger. If you're not a member of CAR, talk to your local LPC member from your local board. We try to make sure it's a geographic distribution around the state. So I know Aaron is one of our members from our South Metro Denver Realtor Board, but just talk to an LPC member. They just got their letters that went out this week. So that's the best way to engage with us, because that's how we take positions starting in January.
And it also puts you on the list to go down and testify. So that's always fun. If you haven't had the pleasure of doing that, that's intense. It looks like we had somebody, Amy, we live in the mountains and there's no way that we could get an inspection completed, assuming the agency prior to the tenant coming in may not have come with a Section 8 voucher. Are we supposed to tell all of our owners that we can't proceed until issuing agency gets up here? I think that's a Section 8.
Yeah, so I think that's a pretty unique situation that you'd certainly have to weigh out. You don't want to be creating a situation where you've got such a barrier that you are not really allowing for a tenant with Section 8 to apply. So it could be a situation where your conservative move might be to hold off on renting to somebody else if you've got a pending applicant that's Section 8 to allow that inspection to take place. I think the one thing to keep in mind, as far as, you know, people don't realize what's the consequence if I just refuse to participate with Section 8. What am I opening myself up to? And the answer to that is cost and exposure. So you could be looking at a complaint that the tenant could file with the state, the CCRD, which is a division of DORA, the Civil Rights Division, that could investigate the complaint. The cost of the tenant to file that complaint is zero. They would just invest their time in making that complaint. And then an investigation would be opened. You'd be required to provide information potentially related to that interaction with the tenant. And then even beyond that, interaction with other tenants that you might have too. That can be time consuming. It can be expensive if you're hiring an attorney to help you with that. So there are good reasons, just that alone, as far as looking at that consequence for compliance with those. And I think that's an important thing to make sure that your owners are aware of, because they might not fully understand that why do we have to do this? What's the incentive to do this? And but I think a lot of people can be motivated when they understand that there's cost and there's downside if we don't comply.
Question. So if I have a house that's like built in 1956 and it has a non-conforming bedroom at the basement, I know some of these voucher programs count bed, you know, what's a bedroom and what isn't. Through that inspection process, can they force an owner to put egress in and make it a conforming bedroom, or any idea how that works?
Well, I mean, I think you know, looking at that, you could be looking at a situation where they wouldn't count that as a bedroom, and they wouldn't consider that as a bedroom too. So that could potentially have an impact on the voucher. as opposed to mandating that change to that situation. So there could be a couple things that might play out from that.
It says if an owner manages their own investments, do they need a license? I'm assuming they're talking about in Denver.
Well, so there's a requirement at the state level to have a license if you're managing properties for a third party. But there's also an exception to that state requirement that if you're an owner managed property, you don't have to have a license. So certainly an individual that is managing their own property, they don't have to have the state license, the brokerage license. If they're in Denver and they're renting a property though, they have to have the Denver rental license, right? Everything's called a license, right? So it can kind of get a little bit confusing, but there's that difference between that Denver license, which everybody would have to have, and then the license if you're licensed with the state to third-party fee manage. But that's where I think the real trigger on the state license is required. If you're just managing your own property around the state, you don't have to have a license at the state level for that. But if you're managing somebody else's property, then you do have to have a license at the state level.
Awesome. Does a brokerage license for managing property for others need to be an employing broker level? And I think some folks need to be careful between the difference between licensing and your employee office policy manual.
So the brokerage license level, if you're your own, if you're running a brokerage, you have to be at the employing level broker, right? So if you're an independent broker, that can be sufficient as well for managing property. If you are just a broker, but you're hanging your license under Exco Management Company, you have to make sure that your employing broker and your office policies allow you to engage in property management. Because believe it or not, there's some brokers out there that are like, I don't want to touch property management, right? They don't want the headaches of dealing with the accounting that is required, and there's specific accounting requirements. They don't want all the other challenges that are associated with property management to deal with, and they just want to focus on sales. So hope that helps.
Awesome. Did we answer Jan and Amy's questions? Does anyone else have their hands up? Scrolling.
It looks like there's another one that just popped into the chat there, Aaron, from Teresa.
Oh, there you go. If you self-manage your own properties, do you need an escrow account for the security deposit? That was a change recently.
So it depends if you're a broker, right? So if you're a broker, you do have to have the security deposit escrowed, and it has to be separate from any other accounts. So if you're a broker and you're involved in property management, you can have a brokerage escrow account that has multiple security deposits from different tenants in it. Except if you're managing your own property, then you'd have to have a separate escrow. If you were not a broker and you're managing your own property, you do not have to have your security deposit escrowed, with the exception of if you're in Boulder. In Boulder, you have to have pay interest on the security deposit. So that question alone just highlights all the challenges that are involved in dealing with property management, right? There's a lot to it.
All right. We're coming down to our last couple of minutes. Just scrolling through. Anyone else need to go live on camera with a question, or any other new ones in chat? Any other final remarks from our panelists?
I wondered if
Liz,
oh,
please.
did Liz have her hand up first?
No, she was without words for once. Wow.
I was just going to make a quick mention of something on the advocacy side. One thing that I hope isn't lost on this group is that even though we have a challenging environment at the Capitol on these housing issues, the small landlords and property managers still are a sympathetic group. You're looked at as small business people, you know, out there on the front line of providing housing for people, especially in that single family and smaller multifamily space. And, you know, one thing I hear a lot from legislators that I wish I would have brought up earlier is that your industry tends to like to get together in smaller coffee groups and compare notes and you know, kind of have that sense of community. And I get a lot of requests from legislators who are either have friends in the community that are part of a group like that, or they want to figure out how to get connected. That's very powerful to the advocacy side, just building that kind of a relationship. So those of you who do gather in that way, really encourage you to make that connection with your local legislator, and just to be able to keep in mind that they really have you on the radar as part of that. And many of them would like to connect with you. And a lot of them actually are small landlords themselves, even though they don't talk about it a lot at the mic at the Capitol. It's interesting how many are involved or have a family member involved. So just wanted to leave you with that thought.
Yeah, I've seen it firsthand when we were down at the Capitol that you bring in that small mom and pop landlord or that overseas veteran who's renting their house out while they're gone and hopes to come back one day. And those folks, you know, get heard really, really well. And as the market shifts, I know there'll be a lot more people that may need to rent their homes for a couple years that maybe weren't intending to be a landlord, and their voices matter. So it's important to be here and to be active. So thank you guys all for coming. I want to give a big shout out to Peter, Laura, William, Liz, Jesse, and the rest of the CAR staff, Lisa, Holly, and Adela, who put all this together. There's a lot of work that happens behind the scenes, and it wouldn't happen with all the things they do. I will be coming off this committee after today, and the chair of it next year will be Micah George, who's also an LPC member. So she is, you know, going to be open to hearing what you guys want to hear and who your speakers want to be. So let's give for those on camera, let's give a round of applause for our speakers today, because they gave up huge time to be here, and it means a ton to us. Again, this is being recorded, so that if you didn't catch it all and you want to go back and listen to parts, or you need some of the notes from the chat section, those should be available within the next week or so. And anyone that's registered should be able to get a link to it. So with that, is there anything else from staff that I have missed? Because that could easily happen.
We're in great shape. Thank you all so much for your time today.
Thank you all. With that, I will have our meeting be adjourned. And if you need any contact information, please reach out to CAR or myself directly.
Thank you, everybody.